Guardianship and grandparents. We recently had a grandma that, due to grandparents' rights, she said she had gotten the custody of her grandkids. And, at first glance, it may seem that it's that easy, but it's not necessarily. Question becomes, can any grandparent automatically become the guardian if parents pass away? It did work out for that grandma, but the harsh reality is that it's not automatic. So, I'm 𝗕𝗲𝗰𝗱𝗍𝗍𝗍, of Zammitti Law, an estate planning attorney in New York and New Jersey. We provide peace of mind to families through our high client value services. And if you need assistance in either estate planning or the administration after the loss of a loved one, you can reach out to us for a free consultation at yourplanningattorney.com. And speaking of value, we are also here always educating for free. So please ask questions and don't forget to share so that together we can help some folks along the way. Grandparents' rights, guardianship, how does this all work? So there certainly are cases where the grandparents are the right parties. They successfully receive that authority and can care for their grandchildren when these scenarios arise. But in many cases, that's not going to happen. The court doesn't just assume that the grandparent is the right fit or can do it, etc. So it really comes down to state law, family circumstances, and any competing claims. There can be more than one person seeking to be the guardian of those minor children. So when you have potential of additional parties who may want to care for these children, there's could be a chance of conflict, delays for certain, and definitely money spent that should otherwise be there for the kids. And truly the best way for you as the parent to take care of your children and make sure that your wishes are going to be honored is to legally name the guardians and or a successor or two under your estate plan. And even then, you should know that this is really only suggestive to the court, and they will still decide at that time if those parties you've designated are the right individuals and in the best interest of your children. You want this because certainly circumstances can change, right? If you name a parent now, which is a grandparent, if they're in their 60s and can handle raising a little one or young one, great. But 10 years from now, if they're still minors, can that parent still handle like a teenager, right? I'm not certain of that. And we want to make sure that the right parties are in the place when your children should need them or if your children should need them. The court's going to give priority to the individuals you've legally named, right? And the process can be a lot cleaner and smoother in that way if you've done so. And certainly make it much easier for the children as well who are dealing with the loss of their parent, you as their parent. So if no guardian is named, the court is going to ultimately choose someone, and it just may not be the grandparent. It may not be the party you would have chosen. Who knows? It's really up to the discretion of a judge. So please, if you have minor children, just don't leave it up to chance. Make sure your estate plan designates a guardian and maybe several backups to give clarity to your family and peace of mind, right? Taking that time now to protect your children's future should any of those what if scenarios of life catch you off guard. Again, I'm 𝗕𝗲𝗰𝗱𝗍𝗍 of Zammitti Law. We're an estate planning practice here in New York and New Jersey, and we provide peace of mind to families through our high client value services. If you do need help with either estate planning or the administration after the passing of a loved one, you can reach out to us for a free consultation at yourplanningattorney.com. We truly hope that you've learned something new here today. And don't forget, share and take care. Bye-bye.